Tonight is part 2 of conflict resolution. We had a great conversation the 2 weeks ago with John, and then some good discussion. He left everybody with some homework, and hopefully at some point he's going to take the time and create that into a book. So you guys got like a good preview book of John's. So that's a good thing. But we'll kind of finish up the part 2 conversation of this, and then next week. I kind of like tonight's topic too, because we're going to roll a little bit into next week, which is kind of preparation for expert witness stuff. So we did your bio in week 1, so we'll leave some more time for John to present tonight rather than reading his bio. So as always, John, we love your time here on Mentoring Mondays, and of course your expertise in jumping in on Wisdom Wednesdays as well. We love those kinds of conversations, which is all similar to what we talked about tonight and last week. So I will turn it over to you again, and I appreciate it. Thank you, sir.
All right. Well, thanks much, and thanks for the re-invite. Hopefully everybody had a chance to kind of review some of that material that I've thrown out there. In this short a period of time, basically what you're reading and looking at there in that material is boiled down to an 8-hour presentation that could be really 2 or 3 days. And we're boiling it down to 2 hour-and-a-half sessions. So we're quite condensed. And so anytime you have any comments, questions, whatever, feel free to jump in here, because there's a lot to cover. Let me share this screen and get started with some of this presentation. I wanted to kind of touch base a little bit with, hopefully you can see that.
Not yet.
Not yet?
Not yet.
Share screen 3, share.
There we go. Now it's popping up, and there you go. Yep, we're on the page. Yep.
And so, yeah, see if I can make some sense out of this. No, not really. Okay. So just a couple of recap issues, just to kind of get you back where we were what we were talking about last session. I've got a couple slides here to kind of review a couple of points that I feel I've got a different perspective than most surveyors do. So hopefully I can kind of bring those back to the forefront and get you thinking about them, because there's some key concepts there that really we need to pay some close attention to. This was an epiphany for me when I just really figured this part of boundary law out, and it really helped me a lot to help separate, categorize these boundary laws, title law, conveyance laws, these different categories of laws that we deal with on a daily basis when we're determining boundaries and their locations. And I found a few cases that relate to this real well. A couple of them are in the materials. There's some great Alaska statutes on the issues, as well as some good court cases across the country that talk about this 2-step process. When you're talking about any boundary line, there's 2 things that have to happen. One thing has to be created, which requires the intention of the landowner. Whoever owns the field, the 20-acre field, who decides to sell 10 acres and create a boundary, well, when he sells that property, he creates a boundary. And that's the only way boundaries get created, is by intention of the original owner to sell part of their property. That's the only way you can create a boundary. And all intentional sales of property, conveyances of property like that, must be done in writing. Statute of frauds in all 50 states requires those to be made in writing. Not necessarily duly recorded, but at least they're put in writing somewhere. Statute of frauds requires it. So for every boundary, you've got a written document that creates it. That could be a deed, could be a will, could be a statute, could be a number of different ways that these boundary lines are created in different types of writings. But they have to first be created, or at least at some point be created. And the second thing that has to happen is they've got to their physical location on the ground has to become established. And the only people with the authority to establish those boundaries are the two adjoining landowners. They're the only people who can say, here's my boundary, and can recognize it and work together as landowners to say, this is where it's at. So this process of establishing the boundary on the ground, Skelton's book I mentioned last time has a great chapter on the rules of establishment and these establishment principles, because every boundary that's fixed physically on the ground, it has a known physical location, has been physically established by some operation of law, typically through the actions of the landowners. They might hire a surveyor to mark the line, then the surveyor's markers are intended to be the marking, and then there's reliance upon those markers. And so you've got intention and representations and reliance and a number of different little principles that come into play. But you're looking for physical evidence on the ground that establishes the location of the boundary. Once you have those two things, the boundary line is fixed. And we as surveyors, we get all hung up on the fact of an original monument that we like to call it, or what we like to call an original monument, is really a monument that has intended to mark a boundary that was created, and it was, and the landowners have established some physical location of that line through their actions, their intentions, their operations of law. So those two things will happen on every one. And with an original monument, the boundary is the first, the monuments are established first on the ground, and then the conveyance happens that they sell the property and create the boundary. So the monuments establish the location of the boundary before the boundary is ever even created. And the creation of the boundary and the operation of fixing these monuments kind of becomes almost a conglomeration of those two steps that happen concurrently. But monuments control over course and distance because they're intended to, things like that. So all those principles are very real principles that we rely upon as surveyors. But then another thing I wanted for us to reconsider here too is that is this three-step process that happens in the courts every time the courts determine a boundary. They gather the evidence, and it's the same thing we do when we do a boundary survey. First thing we do is gather evidence. We've got the documentary evidence, the deeds, surveys, maps, plats, all sorts of documented documents that are written in written form. We've got demonstrative evidence, the stuff the field crew ties down, the found iron pipe and the fence line and all the physical objects that we locate on our surveys and show the spatial relationship with. And then testimonial evidence. What did the old landowners say? You get that guy in the bib overhauls sitting up on a witness stand and telling the judge, yeah, I know where that line is. Judge is going to listen to him. Testimonial evidence is very important evidence, sometimes the most important evidence. But all evidence we gather as surveyors is one of those three kind of categories. Once we have the evidence, then we have to determine what facts are proven by that evidence. You prioritize it, you weigh the evidence, you apply the rules of evidence, and go through this process of analysis, analyzing the evidence that we gathered to determine what the facts of the case are. Once we have the known facts, then we can apply the rule of law to determine where the boundary line is at. And every boundary determination requires that application of some legal principle. And we do them all the time. Most of them we don't even think about. But there are some that we are less comfortable in applying than others. But they're all just legal principles applied to a fact set to tell you where the boundary is. And if it's a title law, then it's going to resolve a title issue. If it's a boundary law, it's going to resolve a boundary location issue. I mentioned Cooley's and gave you a couple of Cooley quotations last time, but I wanted to reiterate this one where he says in his 1881 article, Judicial Function of Surveyors, he says, surveyor, on the other hand, must inquire into all the facts giving due prominence to the acts of parties concerned, always in keeping in mind that the courts and juries are required to follow after the surveyor over the same ground, and it's exceedingly desirable that he govern his actions by the same lights, same rules that they will govern theirs. Those rules that the court follows when they adjudicate a boundary are the exact same rules that a surveyor applies to determine the location of a boundary. It's the same process, same procedures, same rules of evidence. It's the same. There's just no difference. It really came as a surprise to me the more I got involved in the litigation and the mediation side of boundaries and fixing these problems that we're confronted with. Finding it and making that connection between what's going on in court and what's going on our everyday practice, they're the same thing. We follow the same procedures. When you sit down and read the rules of evidence, you can say, yeah, I do this, and yeah, I do this, and I'm trained to do that, because we follow those rules. Those are the rules that govern our profession. And so what are these rules? These establishment rules. How does a boundary get established? And there's only 5 doctrines really, and 4 really is more correct. There's 4 boundary doctrines: parole agreement, implied agreement, and equitable estoppel, and practical location. Those are the only 4 real boundary establishment doctrines that there are. Adverse possession is really a title doctrine that under very limited circumstances in some states, there are statutes that allow a long-term possession of land without a deed. You go in and you take possession, you occupy the property, you turn it into productive use, you enclose the property with a substantial enclosure, and you're there for a fairly long period of time. The courts, the statutes, the legislature will recognize your ownership of a brand new parcel of land. And when it does that, only in that slim part of the kind of application of that doctrine will create, not only clear up the title, quiet the title, but it'll also establish the location of the boundaries as they're possessed.
Schroeder's got his hand up. I don't know.
That one being a title doctrine is a little bit different. The rest of these are purely just where's the boundary doctrine. You want to know where a boundary is? Well, is it in how has it been established on the ground? And most of the time, the boundary lines that we, when we go out and gather evidence and recognize the position of a boundary, it's because we're trained to do it that way. But when you break it down, the reason we're trained to do it that way is because there's a legal principle that requires us to do it that way. And when we apply that legal principle, we end up with the results that we are already reaching. It's just a little different twist on the perspective of how we really look at our responsibility and our role to society as this quasi-judicial role.
Hey, John.
Yeah.
Schroeder has his hand up.
Oh, okay.
I'm sure it's along those topics, but yep.
Yeah, so great, John, and not to rabbit trail too much. So it's very interesting here in Alaska. We'll put a little Alaska uniqueness in here. When they had to settle the Aboriginal land claim so that the oil pipeline could be built in the mid-70s, so the Alaska Native Claim Settlement Act, Alaska wasn't too far out of being a state, which was 1959. So this is like, 14 years later or something. There were all these people that had just been living around villages and personal places of residences. There were historical sites and so forth. So Congress wisely says, rather than adjudicate all this stuff and have claims and have clouds on title, they put a section in ANCSA, the Alaska Native Claim Settlement Act, to allow for those people to make, their statement. There's a set process, and very, very unique surveys, because you have somebody out there, and then basically it's pretty much like adverse possession against the federal government with the legality. And when I left being cadastral chief, there was, I think, something like half of the villages had these. And so this could have been, typically it was like a non-native person, and the natives became non-nomadic, and they became quite contentious. But most of that all got sorted out and agreed upon. And then there was a notice posted, you know, for any claims against the settlement to give these people their lands. But as a surveyor, you're just going out there and, well, this guy's got a house and a cabin, and he's saying, well, I use this. It's pretty unique. So anyway, that's the only time an adverse possession kind of, you know, didn't follow the statutory stuff that's in the state laws, that basically the people were on the land. You had to go find what would be a suitable boundary to them and their neighbors, and go through this whole intricate process. So
yeah, and then you go through the
government
claim
fashion, they're
process.
still working on it. So
yeah, but it's up to the surveyor to work with the landowners to figure out where their boundary is, or where they think it is, and where the limits of their claim are. And we had a similar situation like that here in Utah, actually, with the early pioneer settlers, where they were basically squatting on the federal public domain lands for some of them as long as 50 years before they ever were able to get an actual title, a patent from the federal government. But so they had invented their entire land claim process. You had to have a survey done. You had to publish your land claim, your claim in the paper so many times, and you had to go before a land court to get it adjudicated that yes, you are the proper claimant for this land. And yeah, all these public notice processes. But yeah, those are all statutory processes in order to establish that claim of title. And you know, we had the homestead laws and all that stuff, and with the patents is what we're kind of used to looking at. But no, there's a lot of other stuff out there that establish these land titles, at least land claims, and then converted those claims into actual title. One of the interesting things with these establishment doctrines is this statement here, where it says all of these principles share similar policy foundations to promote the efficient use of property, reduce litigation, establish a status of repose, remove stale claims, and avoid the necessity of producing evidence of events from the distant past. That's why we have these things, is to prevent litigation. Now, the way I was taught under Brown and a number of the other established authors was that our job as a surveyor was to go out and find these discrepancies and these difficult, these boundaries that were difficult to determine, and just show the facts on our survey, hand it to the client, and tell them to go call the attorney to solve any problems. Well, how does that prevent reduce litigation? How does that promote efficient use of property, or take into account the status of repose? The only way this happens is if a surveyor recognizes these rules and these principles and applies them as the rule of law governing the location of the boundary in every case. And it's the only way that it ever happens. Otherwise, we are promoting litigation, and we're taking these stale claims, these old, long ago created problems, and bringing them up to the forefront and kicking that sleeping dog and handing it to a client, and sending it off to the courts to decide. Well, that's not what we were originally doing, and that's not what Cooley has told us we should be doing. So there's quite a bit of things, quite a number of things that we can consider in these doctrines. Now, most of us, I was also taught that under these doctrines, well, these are those unwritten rights and unwritten title doctrines. And we see that buzzword all over in the textbooks, and we talk about it and we hear about it in conferences and such, this idea of unwritten title. Well, the statute of frauds says you can't, unwritten title there's no such thing. All 50 states outlaw unwritten title. You cannot, all title transfers have to be made in writing. So it goes against, it flies right in the face of the statute of frauds when we call it unwritten title. I actually did a research one time, searched for the term unwritten title in every jurisdiction in the entire country. And I came up with 0 court cases that use that term. And yet it's a common term we use in our profession all the time. I also searched for unwritten rights, came up with about 4 cases that use the term unwritten rights. Those were all in relationship to prescriptive easements, where you acquired the right to use someone's land without a writing, through oral permission, basically, or just the fact that they allowed you to use it. But the idea of unwritten title doesn't fly with the courts. It's contradicted by the statute of frauds.
Schroeder's got his hand. He's ready to go again.
Well, just quickly, because I know there's a lot of these RS 2477 right-of-ways in Utah as well as Alaska. So those are bugaboos too, because those rights attached at the time of use, and it's really hard for a surveyor to find the location of them.
Right. That's because there's statutory grant that just says, yeah, go out there and build roads where you need to have roads that go to across the public domain land to go to your homes, your towns, and your mining claims, and your timber lands, and your homesteads, and all of these things, all of the things that the legislature had given the settlers the right to use the public domain land for. And then they just had this one sentence that said, yeah, you can build roads across the federal public domain to get there. And there's a lot of, I think, misconceptions about that whole statute, because most of the litigation that goes on with about 2477s is dealing with public roads. Well, it doesn't have the term public road in there anywhere. It's any road built by any settler for any one of the public purposes. They could build a road to get to their homestead. Did that make it a public road? No, probably not. Made it a private road, I would guess. But it's a lot more broad than just arguing public road issues. But yeah, 2477s, we can get off in a whole big long rat's nest, especially here in Utah, Nevada.
Yeah, that'd be a whole day we could spend on that.
We should probably do a presentation on that. Somebody's got enough knowledge on that. But like here, like he says, in Clark County, Las Vegas area, the county has a map that they've kind of gone through and drawn what was 2477 rights at the time. The states are kind of in the process of at least laying their claims and saying this road is, that one's not. But there's a lot of misconception, because they're only laying claim to what they say is the public roads. Right. That doesn't eliminate the private 2477s that nobody's talking about. Yeah, for sure.
So boundary agreements. Here's out of Tiffany on Real Property. Says an agreement between adjoining owners is the location of a boundary line, even though it's oral, is not invalid because it doesn't involve the statute of frauds. What's happening here with a boundary agreement is that you really have two neighbors entering into a contractual relationship to establish their location of their boundary. It could be a buyer and a seller on the original line. It could be just two subsequent owners that don't know where their line is, and they make an effort to determine where that line is because they need to know where their boundary is. And so it's some contractual agreement. Well, there's only 3 kinds of contracts, and all of these agreement doctrines are based on those 3 contracts. You got oral contracts, written contracts, well, 4 contracts, I should say, 4 oral and written contracts, which are really expressed contracts. And then you have implied contract, which is just based upon their actions of what they did and what they seem to have agreed to over some period of time. And then you have written contracts, or let's say oral contracts, implied contracts, and then you have the idea of estoppel or part performance contracts. And they're all valid contracts. And it's just a contractual agreement between the owners that says, I don't know where our boundary is. Let's get together and decide where it's going to be. And they can do that through a number of different actions and operations. But the contract is not to convey land, because that would require a written conveyance under statute of frauds. So they're not agreeing to convey land. They're only saying, well, we already own up to our boundary. We just don't know where our boundary is. And so we're going to do whatever the law requires of us to establish the location of the boundary. And those are the establishment principles. They've got to follow those rules of law in order to establish and fix the location of their boundary. Says the agreement does not in such a case involve a transfer of land. They're not agreeing to buy and sell property. They already know they own to their boundary. They have a deed that says this is mine and that's yours and we're adjoining landowners. We just don't know where the boundary is. So we establish this location. The conveyance documents to get the deeds created the boundary. We don't know where it is. So now we'll enter an agreement. Here it is. But that agreement comes in all sorts of forms: original surveys, original monuments, subsequent surveys with subsequent monuments, actions of parties over time. They might involve a surveyor, they might not even involve a surveyor. Number of different conditions that can arise. So if you take these four doctrines, there's also this doctrine of practical location, which is another type of doctrine that's estoppel is, usually it's an agreement, a contract is an agreement between two parties. Estoppel is kind of a representation by one of the parties and reliance by the other. So it's kind of a give and take type of a contract. And then practical location is one where we just flat out don't know where what happened or why. But what we do know is physical features of property. But every one of these boundary doctrines involve these three things: an assent, which is an agreement between the two parties, the meeting of their minds, that's entered into in good faith, the bona fide rights and bona fide occupation and those kinds of things that we read about in the manual. That's the good faith, that they have to enter that agreement in good faith. And once they've agreed, they have to be mutually satisfied with that agreement. If they're not satisfied, well, they're going to say something. They're going to say, no, that's not what I agreed to. And they're going to clarify the terms of their agreement, however. But it's going to involve those three things. And each one of these doctrines has specific principle parts of it that answer those three questions. For example, per oral agreement, that they got together and they agreed, here's where our boundary is going to be. And it was the purpose, the reason they got together was because to settle an uncertainty or dispute over the boundary. And they executed it. Once they've agreed where it is, they can't just walk away and do nothing. They have to actually execute the agreement, which is by physically building and constructing some physical improvements, a fence or some barrier or improvements that are related to that. Maybe they measure over 12 feet and for the offset to build their house. And that's enough to say, yeah, okay, here's where the boundary was agreed to be. Implied agreement, it involves time. Mutual recognition, acquiescence in the line as a boundary, and time, it goes back to the rules of evidence where anything over 20 years, you're expected not to remember a conversation you had 20 years ago. So if it's been more than 20 years, the courts just say, well, even if you did have an oral agreement, you forgot about it by now. But the remnants of the agreement, that execution of the agreement, is still physically present. So that fence has been standing there for more than 20 years. That's the physical fence that satisfied their oral agreement. The courts will imply that, well, at some time in the past, they must have had an agreement because there's the fence. And they've treated the fence as their boundary for 20 years, and so it's the line. And it's just a contract that's implied over this length of time. Here in Utah, it's 20 years. A lot of jurisdictions, it's 20 years, some 19, some 18. Just depends on your jurisdiction. Estoppel, representation by one, reliance by the other, intended to establish the location of their boundary. And then they have incur substantial costs. They put in improvements and fences and retaining walls and plantings and irrigation systems and start to incur costs based upon that agreement or representation and reliance. And so it's more of a, rather than a passage of 20 years in time, it's more of expenditure, of a substantial expenditure that now if you made them go back to where the true line or the correct line or the surveyed line or the title line, however we got tons of names for these things that really aren't boundaries. But if you made them change, they'd have to now tear all this stuff out and redo it. Then you have practical location. That's kind of the rule of last resort, which we always have in all the boundary laws. There's always a rule of last resort that says, if you can't figure it out, well, what's there on the ground is still the better evidence of where the lines are supposed to be than the original monuments, which are now gone, the original survey, which we don't know who did it when. All of the direct evidence of the location of those boundaries is gone, but there's indirect evidence left now physically on the ground. Usually it's several parcels created at the same moment in time, and you can take their deeds, and if you rotate it and shift it over to here, it fits. Well, that's practical location. It says, I don't know how they got here, why it's rotated, why it's shifted out of position, but when I do that, all the improvements start to fit into place. And so the improvements on the ground become the best available evidence of the original survey that was done. It's just that the monuments in the survey itself are unknown at this point in time because they're just lost to time, lost in memory. So that's practical location. And here again, they say, although much is said in the cases about estoppel and expressed agreements of boundary line, the real justification to the doctrine is to stabilize title to real estate and prevent uncertainty and litigation. Here again, we see this concept of preventing litigation. How is it a surveyor is supposed to go out and ignore these doctrines? We're told we got to know what they are, but we can't do them. Well, if we don't do them, we're going to promote litigation if we don't take these things into consideration. And there are ways for us to deal with those. And we're given lots of instruction. This is a case that I want to go over that happened just actually probably a mile and a half, 2 miles away from where I live. That 1979 subdivision, Barr versus Imus, 2011 is when it went to trial. But no, that's the appellate case. I'm not even sure if that's the date for the first one or the second one because it got appealed twice. But 1979 subdivision. And in this subdivision, we have this big Buckingham Court, and there's this square box in the intersection here. That's a monument with a hand well with a ring and lid. You pull the lid off, and there's a brass cap with an X on it. And over here at Greenwich in Buckingham Way, there's another one, hand well with a brass cap with an X. When you measure the distance from X to X, it fits the plat within 0.03 of a foot. The bearing is east between the plats, and the sidelines of these lots goes south. So it's really easy. I mean, any surveyor can really simply figure out where these lot lines are. But the parties themselves who took title, Imus ends up takes title to lot 413 and builds a home on it. I think, yeah, here we go. Imus gets 413. Dalton takes a lot 414. Those are the two original purchasers, build their house. They still, let's see, Dalton now is sold, but Imus still lives there. And Barr is a subsequent purchaser. It originally was purchased by Wyman, and then it went to Carlisle, I think it was, and then Carlisle sells to Barr. And so from 1979 in this subdivision, I think they started building their properties or at least putting up the fences between their properties in 1983. So simple subdivision, you would think, what's the problem? I mean, this can't be too difficult. When this thing goes to trial, they do it on a summary judgment, which means we agree to what the facts are. And here's what the facts are. Subdivision 1979. Imus purchases in 1983. Imus contacts the neighbors because he wants to build his backyard fence. He wants to fence in the backyard. Dalton owns 414. He's the one on the east. He agrees to split the cost of the fence with Imus. So he'll pay half, Imus pays half. Wyman on the opposite side, on the west side, the predecessor of Barr, he says, well, I don't want to pay any money to build to buy the fence, but I'll agree to share the labor costs. I'll help build it. Imus agrees to pay for the materials. Not knowing the actual location of the plat lines marking their boundaries, the neighbors decided to set the fence locations based on their own calculations and use of a tape measure. Go to Home Depot, anybody can get one, right? All the neighbors came to a mutual agreement regarding the ultimate location of the fences, and although the parties understood that their measurements were inexact, each party was satisfied because their calculations showed that each neighbor's backyard measured 80 feet between the fences, consistent with their plat. So they're entering into this agreement. They're satisfied with their agreement. Even if it's inaccurate, they're still satisfied. Well, Wyman assists in making the measurements. Imus begins this extensive landscaping, $7,000 to $9,000 worth of landscaping. Now, this guy's lot is filled with, I mean, it's a forest. It's completely filled with trees. I don't even think he has any grass in this entire place. It's just all trees, big trees. Now, Wyman, in 1985, Wyman sells to Carlisle. So just 2 years later, Carlisle buys it. So when Carlisle buys it, the fences are already there. Carlisle continues to treat the fence as a boundary, and Carlisle sells to Barr in 1988. So Carlisle's only there for 3 years, but the fence was there when he bought it. Fence is there when he sells it to Barr. Barr comes in, there's the fence. All these improvements are already in. And Barr and Imus enjoy a neighborly relationship until 2003. So from 1983 to 2003, close to 20 years, it's arguable between the parties whether it's 20 years or not. But they've got a neighborly relationship. So everything's fine with them about the location of this boundary. Now, Imus claims the dispute arose in September of 2003, which puts it over the 20-year mark. Barr says, no, it was earlier than that. We started fighting about this over, before September. So it was within 19 years. And they're arguing that because if it's more than 20 years, you got acquiescence, right? 20 years of acquiescence. The dispute. Here's what brought on the dispute. Although the precise timing of the dispute is in question, the reason for the dispute is clear. Imus's had previously planted a Russian olive tree on Imus's side of the fence. You all know what Russian olive trees are? They're these nasty trees with these little tiny leaves, elongated leaves that once they fall on the ground, you can't sweep them up off of concrete. They just stick to the ground. And they have these little olives on there that they puke out onto your driveway that stains the driveway with these reddish orange things. And they're horrible trees. And they have thorns about 2 inches long on them. So they're planted at every property corner here in Utah. You got to climb in this thorny bush. If it's not a Caragana bush, it's going to be a Russian olive. And so they're horrible trees. So Barr goes to Imus and wants him to remove the tree. Well, Imus says, well, yeah, I got no problem. You can take out the tree if Barr pays for it to take it out. So he's basically saying, yeah, sure, go ahead, take the tree out. Well, Barr says, I don't have to pay for the tree. I'm not going to pay to take it out. It's your tree. And so that's what starts their dispute. what, $250 worth of tree removal, something like that. An extensive dispute between bars and IMUSs ensued, included multiple calls to the Sandy City municipal authorities, get the building department, and complain about setbacks and complain about anything they can think of to complain about with each other, till the city's so sick of them they would refuse to even come to their properties anymore, the inspectors. While the bars are embroiled with the IMUSs over the tree, well, Bar's going to go to his attorney. What's the attorney want? He wants a copy. He even needs a survey to show which side of the line the tree's on, right? He wants to know whose tree is it. So they get an attorney says, you need a survey. So Bar goes and hires a surveyor. And here's the survey. Checks X to X within 300ths, measures down. He sets a nail and washer in the street, sets up on the nail and washer, turns 90 degrees and sights down the line. And oh my gosh, there's a rivet in the curb line, lead plug with a tack in it, in the curb that's right on line. He lifts his scope up, and the fence is headed right for that cap, that plug. But the fence, it's partly retaining wall and part fence that veers off to where it's in a straight line. It's just 4.7 feet off in the back. Nearly 5 feet off in the back. So it goes from on in the front to, or within a half a foot at the front to being off at the back. And it's the back corners that the landowners had measured in and set that back corner before they built the fence. So when you look at this kind of a situation as a surveyor, simple survey, I mean, the surveyor just went out there and just did the mechanics and said, whoop, there's your fence, there's your line, there's the lot line. Where's the boundary? That's the question. Yeah, the plat says the boundary is here, the occupation line is over here. Where is the boundary between lot 412 and lot 413? Is it where the plat says always? No, it's not always everywhere. I mean, sometimes it's where the survey is, sometimes it's where the plat says, sometimes it's where the deed says, sometimes it's where the occupation lines are. And I was always taught, well, the occupation lines, we don't do that stuff. The attorney has to do that and promote litigation. There's got to be a different answer and a different way to look at these things.
Rob wants to know where the olive.
Facts. Go ahead.
Rob wants to know where the olive tree is.
Where's the olive tree?
Yeah.
Today?
Yeah. And then Tyler.
Today there's a whole mass of trees along the front.
Yeah.
Between the front corner and the front and where the end of that the first retaining wall is. It's all trees.
Yeah. Tyler had also put in here, which goes along the same conversation. If the surveyor is confident he has located the original boundary line between two parcels, but the adjoining owners disagree with the surveyor's location and both agree the line is somewhere else, can they still use a boundary line agreement?
Well, they've already got a boundary line agreement in that situation. The question is, what should the surveyor do when he comes up with that situation? And I've come to the conclusion that all you got to do is document it. And it's usually a very simple process to document the evidence we recover, document the facts, let the landowners do the documentation, affidavits, a number of different things you can do and different ways to resolve these things. But when you come into a situation like this, gather the evidence and say, well, gee, it looks like, in my opinion, here's your boundary. And here's why I think that. Document that evidence in the form of a narrative on your survey and say, now, am I comfortable with this documentation that I've done, or do I want to take it to another step further? Do I want to have the landowners do the documentation, and then I'll finish my survey? And I think depends on your level of comfort in every situation, whether or not you're comfortable with the documentation you can provide, or whether we need to dive deeper and get more documentation, get it into the record to rely upon. And we'll talk about that here in a minute. But bottom line here is, out of the evidence that we're given, where do you think the boundary is? Where's the court going to make the boundary? And which one of these rules of law are they going to apply? Is it a boundary by parole agreement? Is there a boundary by implied agreement? Well, that's argumentative because it's could be 19 years, could be 20 years, but then they haven't really agreed to that fact. Is it an equitable estoppel with $7,000 to $9,000 worth of improvements enough to establish the location of the boundary? He's got to now tear out a koi pond and a sprinkler system and the retaining wall and the fence and trees that are planted along the side, trees and shrubbery, and a shed that's up against the fence. That's the $7,000 to $9,000 worth of improvements. Practical location, probably not going to argue that one because we have the original monument still in place. What we don't have is the original monument at the other south end of that boundary, the lot line, but we don't have that. But we have the landowners themselves measuring it in and saying, here's where it is. But of these four doctrines, I mean, which one is the fence the boundary, or is the lot line the boundary between the two lots? And because that's the question all the time is, yeah, you've got this conflicting evidence. You got an occupation line here, you got the plat that says it's here, or a deed that says it's here, and who's going to resolve that conflict? And how do we resolve it? And every conflict that there is when the question comes to where is the boundary, every one of those questions is always answered by a rule of law. Has the boundary line been established by the landowners in concert with some legal principle? And the courts will break it down for us every time and apply these rules, same rules of law all the time. Now, in different jurisdictions, they'll call them by different names. Washington, instead of implied agreement, it's recognition and acquiescence. Here in Utah, they call it boundary by acquiescence instead of an implied agreement, but it's really just an implied agreement because that's what a contract is. So they might have different terminologies that they apply to these different doctrines, but they're the same thing when you break them down. They're the same reasons, same doctrines. And I've seen them all over the country as I've gone around and made presentations all over. I just go in and research their case laws, and their cases, the courts are saying the exact same thing that all the other courts are saying. And I just have to grab quotations out of different court cases from that jurisdiction that support the same four principles. Adverse possession is statutory, where the other ones are all common law, case law. So the court looked at this thing and said, okay, oral agreement. Well, I should probably put these in the other order, but is there an oral agreement between the adjoining landowners that settled a boundary of uncertainty or dispute, and did they execute it by putting an actual location of the boundary? Can you check all four of those boxes with the evidence that we're given, or in the facts that were proven by the evidence, I should say? Given the factual information we have, can we check all four of those boxes? If we can check the four boxes, then the fence is the boundary. And it's the boundary because there's an oral agreement between the parties that says it's the boundary. And the courts will uphold an oral agreement every day of the week when it's concerning a boundary, because it doesn't transfer title, so it's not a statute of frauds issue. And here's a Texas case because I just did a presentation in Texas a few weeks ago. But you can find cases, quotes out of all the jurisdictions. When there's uncertainty, doubt, or dispute, as to the true divisional line, the parties may fix it by parole agreement, even though they were mistaken as to the true location of the line. So even if they make a mistake, they can still agree that here's where it is. And and here in this case, yeah, they were obviously mistaken by 4.7 feet. Doesn't matter. Courts never concern themselves with how far off it is. It's just, have they lawfully established the line? Can you check all four boxes? All they have to do is erect physical improvements marking the line and take possession up to the line, either by marking the line or in making improvements in developing their property. Like they say, measure 12 feet over to the side setback for your house. Things like that. Agreements fixing a boundary may be proven as well by acts and conduct of the parties. So when we get these conflicting locations, the only answer that we can come up with is what did the parties do, who did what, when, and how did they do that? And the best way, really the only way to find that evidence is to ask the landowners. Gather the verbal testimony, the oral testimony from the landowners, and get clarification as to who did what, when, why, where, how. Answer those questions. That's gathering the evidence, and it's well within our expertise. I don't know if it's so much as well within our expertise. We have the knowledge, but it's one that we as surveyors don't like to do. We don't like to talk to people so much. And so I think we avoid a lot of times our responsibility to gather that verbal testimony, because that's going to answer most of the questions that arise. So implied agreement, that's the long period of time, 20 years. Occupation to a visible line, yeah. Mutual recognition and acquiescence, yeah. Both of the parties lived there and were perfectly fine till 2003. Both of them recognized that as a boundary. No, never had an issue with it for 19 or 20 years, long period of time. Utah, they cut it off at 20, so 19 isn't enough. So rather than have a trial to determine, well, was it 19 or 20, they just said, well, we don't need a trial because the parties will agree that they had spent a lot of money and did a the estoppel, boundary by estoppel is what they were claiming. And but adjoining landowners, if you can check these 4 boxes, the fence is the boundary. The plat doesn't control. This is an interesting concept. In Colorado, it's a great case because it really helps kind of understand what's happening with this oral agreement. The oral agreement does not create a new boundary. To create a boundary requires a conveyance of title. Well, we're not talking about title conveyance. We're talking about the boundary establishment. And to establish a boundary under boundary law, the parties already own the property. They own up to the boundary already. They just don't know where the boundary is. So the agreement only establishes the location of the existing boundary. Even though a surveyor can go out and prove that it's in a different location and the measurements are different, doesn't matter. The courts are comfortable with the concept that no, they didn't create a new boundary. They only established the existing boundary location. And it's a matter of, well, the deed says this and you measure it to be this. So there's a record and measured, which we don't have any problem when that happens with a public land survey system. But yet we freak out when we're in an urban environment and chasing a few tenths or a few feet. We start getting uncomfortable with it. But in this case, the Salazar versus Terry case out of Colorado, it says acquiesced boundary will not often lie on the surveyor's true location, if ever, right? And when this occurs, the legal effect of the doctrine of acquiescence is to rewrite the deed or the document of title by operation of law. Basically, it's a correction deed or a reformation of that instrument. The language is in that instrument. It says that it's rewritten to reflect the acquiesced change so that the agreed upon boundary becomes the true dividing line. And an acquiesced line becomes in law the true line called for in the description. You see, it's like this mental gymnastics almost, that even though a surveyor could go out there and measure it and say, no, it's in a different place, doesn't matter. The concept, the legal concept is that they've agreed to establish the existing boundary where it always has been. And now you've got a new set of evidence that will clarify anything that's in the deed. So the description of the deed for that boundary location becomes is secondary to the actual agreed location. And it is that agreed location is now incorporated within the deed itself, as if the deed said, and here they say, it's as if the distance column in the deed says go 500 feet, when you really have to go 517 feet to get to the agreed boundary. The deed still says 500, but the agreement, it's as if the deed has been written or reformed to say, go 500 feet to the agreed boundary, and now go along the agreed boundary. And then it says every future deed of the land which copies or incorporates the original description will also be so read. And it eliminates, we have no title problem. We now know where our boundary is. The boundary has been established, lawfully established by the parties. And there's really no issues. All the legal principles have resolved all of the issues.
Hey, John, while you're there, two things. One, Rosalie had put in the chat while you were kind of in your parole evidence stuff about, will a quick claim deed still be an option?
Quit claim deed was, now you're looking for a title, a quit claim deed will resolve a title problem. We're not talking about a title problem here. We're talking about a boundary problem. Okay. Boundary law will fix boundary location issues. Title issues are fixed by conveyances of title, quit claim deeds, warranty deeds, and the like.
There you go.
So oftentimes somebody will grab a quit claim deed and use that to fix a boundary problem, and it's maybe like, you know, killing flies with a cannon, and it might get the job done, but it's the wrong tool for the solution that's at hand. What you need is documentation on where is the boundary. Now that the documentation's done, now finish your survey and document the solution to the problem rather than the problem itself.
There you go. And then George had his hand up there for a minute.
Yeah.
Yep, you're good, George. You're unmuted. Oh, no.
Nope, he's muted.
Oh, you're still muted. George, you're still muted. Sorry. George.
George, go
okay.
on.
Oh, there you go.
Okay, so what I'm thinking in Nevada, as far as I understand it, in order to solve this problem, the surveyor needs to prepare a survey showing the evidence that he's found, documenting the new line, and possibly, and I think this is still doable on a record of survey in Nevada, you could have owner certificates where the two parties involved can sign an agreement, effectively creating this agreed upon boundary, so that this issue doesn't keep coming up over and over and over again. It's rectified once and for all. And if necessary, the surveyor could prepare descriptions of the parcels as surveyed and agreed upon, and those documents could be filed as well.
Yeah,
that would be my approach anyway.
Yeah, and those documents we're talking about are going to vary from jurisdiction to jurisdiction. Sometimes even county to different counties want to see different kinds of documents. I would say to address a couple of issues there. You're talking about doing it on a survey. Some states, like Montana, they file their surveys with the county recorder's office as part of a title record. So they can do a boundary agreement and have both owners sign the face of the survey. Surveyor signs, both owners sign in the form of an owner's affidavit, basically, that that we agree this is where our boundary is. And you do a boundary agreement by survey, put it in the title records, and it's done. But you know, Nevada, when you guys don't put your surveys in the recorder's office, do you?
Yes, we do.
Yeah, we
do.
do.
You do. Okay. So they're
same
given
with
an entry number. They're given an entry number and made part of the title record then.
Yeah, we would be, say,
Yeah.
record of survey file 229, page 61 or whatever, yeah.
Yeah,
Required
and
to
so
search
with that kind of
certificate.
a repository, you have, because it's going in the title record, you have the advantage of the statutory notice provision that says whatever's in the title record, you're bound to know, you're required to know that. And so there's some teeth that are given that thing, and it's part of a title record. Here in Utah and a number of other jurisdictions, our surveys are filed in a public repository, not in the title record. And so it's just simply the opinion of the surveyor. Here's where I think the boundary is. And it has no impact from title standpoint. Surveyors will rely upon prior surveys to determine where boundaries are and to keep the stability in our land boundaries, but it's not, you don't have that statutory notice provision that's attached.
Well, in Nevada, the title companies look at a record of survey as the surveyor's opinion, and they will not use that to change title, at least as far as I know, unless there's some
but that's because it's
agreement.
the title, yeah. That's
Unless
because they're a
there's an
title
agreement
company looking
made.
at title law and looking at, well, we need a conveyance document
Yep,
to fix everything. Well, no, we're not talking about title law, we're talking boundary law. That's why I'd prefer to have this situation like we have in Utah. I can apply boundary law and say, here's the location of the boundary in my opinion, and it's not going to affect title at all. And the title company doesn't get involved in it. The surveyor's responsibility is the boundary establishment part. The title location and the conveyancing of title is for title companies to worry about. We can keep that separation where you now have to put your survey in the title record. It creates that conflict between, they're looking for a title solution to boundary problems, and they don't, and you have to really crowbar those into the record.
and
You
that's
could
why
do
I
boundary
said,
agreements, a boundary agreement, and do basically a joint affidavit between the landowners and put it in the form of a boundary agreement. Put that in the title record, and basically then it's like, okay, we've got this deed for a piece of property that we have to now read as going to this agreement and along the agreement boundary, and now we follow the deed the rest of the way around.
well, and that's why I said to put both owners on a certificate on the face of the survey, if they agree to that, that would give some credence to that, and if necessary, some documentation could be created to revise the boundaries to the lines as surveyed.
Yeah, and then we have to be careful because we have a tendency to want to re-describe both parcels. Well, the boundary agreement only affects one of the boundary, the common
That's
boundary
right.
between the two parcels, not all the other boundaries that go around the properties. And so we have to be very careful not to screw up those boundaries in the process of fixing one of the boundaries. That can be, that's got to be a concern.
That's why all of us as surveyors drink.
So
It's pretty true.
So we got this equitable estoppel doctrine, stuff like that. I wanted to go in, if we can wrap this up somewhat. I guess we got another 20, 25 minutes or so. So
Yeah, you got
we're doing okay, aren't
You
we?
got time. Whenever you're good, yeah.
Okay, we're doing okay then.
Yeah. Will, while you're searching backwards, we'll put in the chat, what about the non-recording states? Does a boundary agreement require a lot line survey? And if so, how would the surveyor research this information?
In the non-recording states that don't have, your survey does not go into any kind of repository whatsoever.
Right.
The only thing you've got to use is the title record itself. My best approach would be, or suggestion would be, to do joint affidavits between the landowners, where they file these affidavits in the title record that say, here's where our boundary, we agree that our boundary is here, and attach as an exhibit to that a reduced or 8.5 by 11 or 14, whatever you can get a size in your records, and give them at least some kind of sketch that goes along with the description you have of that boundary. And all you're doing is describing the one boundary, not the whole parcels.
Right.
You're just saying, I own this piece of property and they own that piece of property according to the title record. And we have an uncertainty, ambiguity, or dispute over where a boundary is. And therefore, in order to settle that dispute, we've mutually agreed, here's where our boundary is, and put that description and an exhibit attached. Put that in your title record, so the next surveyor can find it, and hopefully it doesn't get lost in time. And then go petition your state surveying association to get a freaking repository so you can start filing surveys.
Right.
Because the survey evidence that we're talking about here isn't for the general public, it's for us and our future generations.
Mhm.
That's who the survey evidence is for. And we need to be thinking of our own profession, when we get these repositories set up. There's nothing that stops your state society from setting up a repository where you can upload a PDF file and they can give it a recording date and a way to index these things and make a repository. It's a private record system anyway. It doesn't really, it's not for anybody except us surveyors, really. We're the ones who benefit from it. Nobody else can pick one of those maps and even read them. So anyway,
that's hard to change when you got a state that's 250 years old. You're not gonna let's try to get some of that to change.
Yeah, some of the eastern states, I mean, they're
Yeah.
into their own private records,
Yeah.
and
I like Michael Schroeder put in the chat. In Alaska, there's a regulation and statutory law to allow for minor boundary differences from record, although the minor term is not defined and is subject to dispute and litigation.
Yep, let the surveyor define minutia.
Yeah, that's awesome.
Okay, so then the court looks at these ideas for acquiescence, but here's what the court's come up with then. The trial, 2007 was the trial date. Says that they had submitted this as a summary judgment, which means they're not really having a trial because they agreed to what the facts are. Trial court they just give it to the judge and say, well, here's what the facts are. You tell us what the law says and we'll go home. So they take this set of facts that we already went through. And the trial court said the disputed parcel, the trial court defined or decided that the doctrine of estoppel is what, that the judge, they granted summary judgment on the doctrine of estoppel, which means offense is a boundary because of the doctrine of estoppel. Okay, the $79,000 worth of improvements was enough to fix the location of that boundary. And disputed parcel, and this is the judge's legal description. All the property located east of the boundary fence that is located to the west of the defendant's home and to the east of the plaintiff's home, including that property occupied by the fence. All the property located east of the line running from the north end of the boundary fence to the surveying pin in the sidewalk, which is really in the curb, to the north of the defendant's property, and all the property currently occupied by the defendant's raised planter bed and landscaping between the north end of the boundary fence and the surveying pin in the sidewalk to the north of the defendant's property. That's a legal description you get. And yeah, you can figure it out from there. You can, if you study what those words are saying, it works. And basically, defense is the boundary between A and B. But they're trying to describe that as a parcel of land. Well, there was never any intent by any of the landowners to create a separate parcel of land, to create a new boundary. This is just a doctrine that established the location of the existing boundary. But they didn't like that. So Barr didn't like that ruling, so he appeals it to the appellate court. Well, the appellate court looks at it and says, yeah, well, you got this 20 years issue, and if it was 20 years, yeah, it'd be bounded by acquiescence. But because it's not 20 years, we'll agree with the trial court that it's equitable estoppel. So the fence is the boundary, not because of acquiescence, but the fence is still the boundary because of estoppel. And They've been legally entitled to have a plat map boundary established as the legal boundary, and their actions that stop them now from asserting to their legal rights. That's an interesting thing with estoppel. You'll read it quite often in the courts that the doctrine of estoppel prevents someone from going to court and telling the truth. They're prevented from claiming to the true line or to the title line. They're stopped from claiming to the due line because their actions, their representations, their actions and reliances and things that they've done have established a location of boundary already in a different place. So they can't contradict their own actions and claim, oh, well, no, the true line should be back over here. Can't do that. Can't claim the truth. IMUSs are entitled to summary judgment as a matter of law, 3-0 decision on the appellate court. So every judge is behind it. Yep, boundary by estoppel. Well, they didn't like that ruling, and so they appealed it to the Supreme Court of the Utah. In 2011, came out with a ruling that says, because all three doctrines are implicated here, we take this opportunity to delineate the nature and elements of these doctrines and to clarify their relationship to one another. In so doing, we refine and revise some of the governing elements of the law in this area to distinguish boundary by acquiescence from boundary by agreement. There's this confusion that, well, if you enter into an oral agreement, do you have to wait 20 years for it to come to fruition? And the answer is no. About oral agreement is done as soon as you complete the terms of your agreement. You built the fence. You agree the fence goes here, you build the fence, you're done. You walk away. It's the boundary. No time involved at all. So they clean that all up and repudiate the requirement that a boundary by agreement is be established by proof of passage of sufficiently long acquiescence. So they clean up that part of the law. Under the three dispute theories, as explained and refined below, we find that the IMUSs are not entitled to a summary judgment on the basis of estoppel or boundary by acquiescence, but they affirm that the summary judgment for IMUSs, however, on the alternative basis of an enforceable oral agreement establishing the boundary by agreement on the party's fence line. So the Supreme Court of Utah said, no, it's not estoppel, it's oral agreement. And looking at the same evidence and predicated on the principle of repose and all those kinds of things. Details are all in my material that I presented to all of you. 5-0 decision. I mean, how often do you see a court case with 3-0 and 5-0 decisions? Trial court says the fence is on the boundary because of estoppel. Well, it's appellate court, 3-0, 3 more judges, fence is the boundary because of estoppel. Well, 5 judges look at it and say, no, you didn't have to spend $7,000 to $9,000 making improvements because you entered into an oral agreement to establish a location of the boundary and you built the fence where you agreed upon it and it was done when you walked away. You didn't need to wait for 20 years. You didn't need to wait for spending a bunch of money on improvements. You got an oral agreement that says here's where our fence is. It's done instantly. No time passage at all. They just agreed to do something to establish a location of their boundary and they did it. And it's done. So it's a boundary by agreement. 5-0 decision.
$75,000 later, and they still didn't get what they wanted.
Oh, I would bet that even with the summary judgment alone, they were probably into it, probably close to 20 grand each.
Yeah.
Just to get that far.
Yeah.
Then they got 2 appellate levels, 2 briefs on appellate levels, probably another 20 to 40 grand each at least.
Yeah.
So they're probably into it, 100 to 120, 150 grand, something like that. All over a $250 tree to remove that they had the permission to remove.
Yep.
And the fence is the boundary. This idea of practical location, I want to go in there again, but that's the one where the original monuments are gone. Now, let's go back and relate this to what Cooley said in his article. And here's some of the principles he brought out in his article. A resurvey made after the monuments of the original line have disappeared is for the purpose of determining where they were, not where they ought to have been. That's a doctrine of practical location. Long established fence line is better evidence of the actual boundaries settled by practical location than any survey made after the monuments of the original survey have disappeared. That's practical location there. But long established fence is also acquiescence, implied agreements. A long practical acquiescence in a boundary between parties concerned may constitute such an agreement on it as to be conclusive, even if it had been erroneously located, which is exactly the case here. Same principle, long acquiesced. This is almost, he's got, you know, kind of a combination of different words in there that really fill the oral agreement and the implied agreement and estoppel kind of all in there at the same time. Then he goes on and he says, if all the lines are now subject to correction on a new survey, the confusion of lines and titles that would follow would cause consternation in many communities. Indeed, the mischiefs that must follow would be simply incalculable, and the visitation of the surveyor might well be set down as a great public calamity. That's what happens when surveyors ignore these principles of law and are refusing to apply them, and refusing to express an opinion as to where the boundary is. Yeah, here's your plat line. Yeah, here's your fence line. You'll have to go get an attorney to answer that question. No, Cooley's saying, no, surveyors answer that question. Surveyors gather the evidence. Surveyors look at the evidence and determine where the boundary is. And it's these same principles every time as it'll tell us where the boundary is. Now, when we've got no conflicts and the dimensions are fitting and you got the monuments fitting and the surveys are consistent, yeah, there's no conflicts to fix. And so there's no issues to deal with. We're dealing here with the ones that don't, the ones that have the issues, and where we've been told to just stop work and give it to the attorneys. Well, if you're going to stop work, please do. Stop what you're doing. Have a clause in your contract that says, upon discovery of an uncertainty, ambiguity, or dispute, I'm going to stop work, call the client, notify him of the discovery. Now, I will work with the client to resolve the ambiguities, resolve the uncertainties, to do the additional work necessary to fix the hard stuff until we finally can hammer out a solution that we can get into the record that can resolve the issue and resolve the conflict. Now I can go back and finish my contract, finish the survey at the agreed upon price. And I've got a window of opportunity here where I can get paid to do the hard stuff and to figure out where the real boundary is and to resolve these ambiguities, because surveyors were geared for resolving these ambiguities. We're the best ones to deal with it. He also says in this article that it's always possible when corners are extinct, the surveyor may usefully act as a mediator between the parties, assisting in preventing legal controversy and settling doubtful lines. How many of us have been trained as a mediator or even attempted to mediate? A lot of us, usually the older, after you've been in the survey business for a while, it's like, no, there's got to be something we can do here. And we'll more readily sit down with a client and a neighbor and say, hey, what do you want to do to fix this mess? And let them fix the mess, because the only people who can fix this problem are the two landowners. And if they go to litigation, the first thing that happens is the attorney sends a claim against the neighbor and sues the neighbor for this problem that the neighbor likely never even created. And it puts up a barrier between the two parties who are the only two people who can fix the problem. But now they've got this lawsuit going on, and it puts this barrier up where they cannot communicate with one another. They're prevented from it. They have to talk to their attorney, and that attorney talks to the other attorney who talks to this guy. And the communication lines are completely severed on a litigation. Where with the surveyor, at the moment of discovery, stops work, calls the client and says, hey, we got a problem here. We need to fix this thing. We need to deal with this issue. We need to maybe do some additional stuff so I can finish my survey, research or whatever. Maybe you'll get enough evidence where you're comfortable just finishing your survey and saying, here's your boundary. Maybe it'll take some working out an agreement between the neighbors. Act as a mediator between the parties. Settle the controversy and settle the doubtful lines. Get it documented and then finish your survey.
Got a couple things when you catch a breath there.
What's-
I said we got a couple of things. Schroeder's got his hand up, but then
Oh,
there
on
was
the chat?
yeah, and then there was a one in the chat. After accepting a long established fence as actual boundary location, do you need to monument the fence corners?
The fence is the monument.
Yeah.
Any physical object with the intended to mark the boundary is a monument by definition. So when we think monuments as a surveyor, we think, oh, well, that's a survey marker. Well, no, not necessarily. A fence post makes a better monument than a survey marker because you can see it from 100 feet away and say, yeah, point at it and say, that's my boundary. And from a landowner's perspective, you see, that's where we've got to start wrapping our head around what the judge thinks and sees and what he means when he says things and uses these terms and what the landowners need to know. They need to know the fence is my boundary. Where would you put a monument? Next to the fence post where the boundary isn't? Because the fence is the best available evidence.
And then somebody's going to call it 2/10 off.
Yeah, right. Or a set of rebar and a cap where that's more easily destroyed or disturbed, and say, yeah, it's a 3-foot offset to a fence post. That's where the corner is. Well, no, then the landowner sees a rebar and cap and says, oh, there's my corner, and wants to build a fence to it.
Right.
And say the fence is 3 feet off. We have to be careful on or you put it up next to the fence post, and then it looks like the fence contractor just tore it out and put the fence post in and then stuck it back in the ground.
Laid it back there.
Just locate the fence post, and if the fence is the boundary, call the fence as the boundary.
Yeah.
If you got to extend it to an intersection of the front line or something, and the fence starts a few feet back, well, yeah, okay, set a corner there, set a monument there that's in line with the fence. But monuments are not just survey markers. Monuments are any physical object intended to mark the boundary, right, by legal definition.
Perfect. Schroeder, you had your hand up there too.
Yeah, John, you're so right on. Thank you for sharing this. This has been hashed out on some forum boards. I mean, this topic goes hostile and all styles, but what you said and what you laid out is exactly right. Doing your due diligence of doing the research, talking with owners and so forth. But there is a subclass of what they call fence line surveyors, also kind of put in the same group as lowballers. They just go out, here's the fences, and pound the stuff in. They don't know the pedigree of the fences. They don't know what oral agreements or not, the chain of title. And so you have to do the right diligence, and you've laid this out perfectly here in this presentation. So I just want to thank you for that.
Well, the good part is
right on,
the good
Michael.
part. Yeah, I was gonna say the good part is now we can point them to week 94 of Mentoring Mondays when the conversation comes up, right? Go watch this. Go watch John talk about it right here.
Yeah, we used to disparage the fence line surveyors there for a while. When I first started, that was, oh yeah, he's a fence line surveyor. Well, some of the times they're right, because the fence is the boundary. But
hey, if you're in Vegas, the odds are with you that it's probably the right solution.
We've got to gather the
diligence.
evidence to show where the boundary is. We have to go through the exercise to make that determination, because we're the only profession in the country that can make that determination.
Right.
And so we have to gather the evidence to make that determination, and then we can inform the landowners, okay, here's what the deal is. Here's the different requirements of law, and here's what you've said, and here's what you've said, and here's what all the evidence is, and this is the way I see this thing, and here's what the law says. And I usually don't ever have to tell them, well, in my opinion, this is what the fence is the line. I don't usually have to. As a matter of fact, in Skelton, he's very clear, don't tell them that. When you do, once you figured out where you think the line is, and if it doesn't agree with what one of the parties expects, sit down with them. Don't tell them what your opinion is, because your opinion doesn't matter at that point. They're the ones that have the authority to resolve the conflict in the evidence that will resolve the factual issues that now apply the rule of law, and there's your boundary. So we have to be careful not to be too quick to throw the cards on the table. What I can tell them at that point is, yeah, you got some of the evidence says this and some says this, and we've got a deed saying this, we've got plats saying this, we've got fences saying this, and we've got all this stuff. It's a mess. What do you want to do to fix it? And they'll put that on the table. You give them the authority and show them they have the authority to fix it. Rob. Yeah, now instead of fence line surveyors, now we're disparaging the deed stakers because of these pin cushions out there.
Yeah. And they want them to have a copy.
Another degree. Sometimes the deed staker's right. Sometimes the fence surveyor's right. Which time do you want to be wrong?
Exactly.
So,
if you want to be in one club or another, well, which one do you want to choose to be wrong? How often are you going to be wrong?
Yeah.
John, as I said in the chat, and I've said before many times, our obligation to the adjoiners is the same as our obligation to our client, even though our client is the one that's paying us. And if we don't keep that forefront in our mind, we are not going to solve any problems.
Our obligation is the public, right? That's
Right.
no matter who's paying the bill.
Yeah, and that's our ultimate charge.
Yeah.
Our ultimate charge is.
It is. That's why we're licensed.
Right.
Yeah, that's exactly right. Let me see here. I'll try and wrap this up a little bit if I can.
Yep.
This idea of mediation, for those who are not familiar with it, it's the courts have actually been given the authority by legislature. They've given the authority to the judge to require the parties to actually attempt to mediate or resolve their problem before they're allowed to come into court. They all have this open doors provision at the courts where all can come and all can bring their problems to the court, and the court will resolve them. But the legislature actually enabled the judges, and they've done this in all the jurisdictions in the country that I've ever seen. I don't think any jurisdiction has not have an alternative dispute resolution statute, an ADR statute, mediation, arbitration, these mini trials, summary jury trials, and there's all sorts of different ways you can mediate and arbitrate these issues. But the legislator had to actually give authority to the judges to close the door and say, you can't cross the threshold until you go making a good faith attempt to mediate your problem. Mediation is successful in 80, 85, and 90% of the time. Because the parties have never been told, oh, you can fix this. And all you have to do is come to an agreement as to what you want to do, and we can fix this, and we can avoid all the expensive trial and appeals and all that stuff. And they've not been told that by the attorneys, because all the billable hours walk out the door if the attorney tells them that. But if a surveyor can tell them that before the attorneys get involved, it makes this settlement agreement a much easier to obtain.
Last time I looked, we're a lot less expensive than attorneys because we give away our expertise.
And I would take that to one more level. I would say, if you're doing this and choose to do this, you're going to have to get some training. There's a 40-hour mediation training program you can take through all the states. Most of the states, it's 40 hours. Some have a 50-hour training program if you want to get into family law, divorce and child custody kind of stuff, which not for me, thanks.
Mm-hmm.
But yeah, it was 40 hours of training to learn to really just find out what the tools were that are available for me as a surveyor that I can use to encourage people to enter into an agreement. and to get it documented, and how to keep them at the table, keep them negotiating until they can hammer out an agreement so I can document their agreement so I can finish my survey. And it's basically learning how to use the tools of the trade in this alternative dispute resolution arena. And it's an arena that spans from the most informal, sitting around the kitchen table with your client and his neighbor talking about the problem, to the most formal in a courtroom with the judge in his robe, and I was on the witness stand testifying in a mediation. So it can cross all sorts of boundaries, and it doesn't matter. The courts will do anything to get the parties to just settle this thing so the judge doesn't have to make the decision for them. Because when they make their decision, they can come up with any solution they want. If the judge makes a decision, the only solution he can have is, well, here's the proper application of the legal principle in your fact set. There's your boundary, go home. And he's going to get the same answer that the surveyor would give him. Applying the same rules of law. And he's bound by that. As a surveyor, that's all I can do. They say, well, here's what the law says. Here's where your boundary is, according to my professional opinion. But I don't have any authority to make them now live by my opinion. Same thing with the judge. They ask him, his opinion. Well, he gives an opinion. Then they ask the appellate court. They get 3 judges' opinions. Well, then they asked the Supreme Court and got 5 more judges, their opinions. And then they've exhausted their appeals at that point, and they have to go home and live out their lives in accordance with the ultimate conclusions. But all of those things are just opinions. And the only people, when they go home, they have the same authority to settle this thing as they did when they left, as long as they can enter an agreement as to what they want to do. So they could still go home after the Supreme Court hearing and say, this just doesn't seem right. Can we just do this or this? And they can enter into their own agreement and fix it. And they're not even bound by the court's opinion unless they can't agree.
And at the end of the day, aren't they still living with the boundaries that the fence line created in the first place? I mean,
well, they can agree to move the fence.
Well, yeah, they could, but I mean,
most people
they
won't.
live with these boundaries for 15 or 20 years. I mean, what are they fighting for?
Yeah, and especially when the fence isn't the problem, like in this case, and it usually isn't. It's just something what they finally ended up fighting over. But it usually ends up being more of an excuse to fight than over a boundary, because they've already been ticked off because the guy kicked his neighbor's dog or slammed the garbage cans around at 2 o'clock in the morning or something like that. And that's really when you get through these mediations, it's amazing what comes out in the mediations, because the parties are allowed to just vent their frustrations with their neighbor. And to actually for the first time communicate with one another. Here's why I'm ticked off. Here's what made me mad, and here's how I'm responding, and what made me respond like that is because this is what I perceived. And the other party is saying, "What do you mean? Well, that's not what I did. I didn't mean to do that. I'm sorry. Sorry you felt that way. I had no idea that you got up at 4 a.m. and went to work, and I'm coming home at midnight and bringing in the garbage can. Simple miscommunications or lack of communication.
Life
is what mediation brings out.
Life is too short to live in an acrimonious relationship with your neighbors. For sure.
And most of the time when you're out there for the first time as a surveyor discovering the problem, you're discovering a problem that they both have that they never knew they had. Yeah. And if you can offer them a solution to the problem at that point, well, now you're not presenting a problem to them, but saying, yeah, you got this issue here, but here we can do this. You can fix it however you want to. If you want to do that, okay, we'll do affidavits. If you want to do this, well, we might have to amend a plat. If you do this, well, we might need to do some title issues or some other things. But there's always different options they have available as to how to document their solution. But the bottom line is they don't know what to do. They don't know how to document it. A surveyor does. And in most jurisdictions out here in the West, we have the ability to prepare the documents ourselves. If we don't, if we've got certain states like Texas, New York for sure, a lot of the Eastern Board states have a definition that's very strict for the practice of law, which is preparation of documents constitutes a practice of law. And if that's the case, well, okay, you're going to have to get an attorney involved to actually do the document, and feed him the descriptions, feed him the sketch, feed him all the stuff that needs to be in that document. But yeah, you might have to have an attorney do it. Here, we don't have that kind of restriction on our practice of law, so I do most of the documentation myself. Boundary adjustments, boundary agreements, things like that. And have no problem with doing them at all. But the documentation, that final solution, that's a surveyor's job. Attorneys suck at it. I can't tell you how many times I've been involved in these disputes. They go to trial, they go to court, and they try to come up with a solution, and they get their judgment. The judgment goes in the clerk of court's records, and nobody thinks to take it over and file it with the title in the title record. And even if they file it in the title record, now the recorder picks it up and tries to read this judgment with that description that the judge wrote, and they got no idea of what they're going to do and how to record it or file it against a piece of property. And is it subject to, is it together with, I mean, what is this agreement thing? And working with the recorders, make sure they get it documented, make sure they get it indexed at property. Had one case where we had a phantom parcel of land that went up for tax sale. The recorder's office just wrote a description of a hole in the piece of paper and waited and then put it up for tax sale. Went to trial and proved that the parcel did not even exist. It was a remnant of it was a half the width of a street that actually there was 5 parcels down this from where they had put it on the tax records. Got it all cleaned up, had the judgment written so that it instructed the recorder to remove that parcel from their tax record, and that parcel was in fact half the width of the street, 5 parcels down, and all 5 parcels needed to shift. Well, but only the last one of the parcels and the owners of this phantom piece were really in the lawsuit. And the other 4 parcels were not parties to the lawsuit. So what does the recorder do? Well, they take the parcel out and shift the one piece of property over and put the parcel on the west side, cutting through the middle of the neighbor's house. A couple of years later, I get a call that says, hey, we're still getting a tax notice on this parcel, and we don't know what to do with this thing. Well, I check, and sure enough, the judgment hasn't been put in the record. I get a copy of the judgment, sat down with the recorder and said, okay, here's what's happening. And they refused to shift the other parcels over. And so I was like, okay. A couple of years later, somebody's selling their property, one of the 4 parcels. They come back and said, yeah, we've got a problem here, and we heard you were involved in this thing and can fix it for us, maybe. And I just went in and I did a survey of all 4 parcels, shifted them over where they really were supposed to be, and then wrote boundary agreements for all 5 parcels to sign, and put that survey and boundary agreement back into the title records, and the recorder finally shifted the other 4 parcels over. But it took us 4 or 5 years to get it finally done. Getting it through that stuff, but I kind of liken it to as a surveyor on a construction project. We're the first ones in, running control, tying things down, and starting the survey work, gathering the topo and the boundary info and all that stuff. And then we're the last ones at the end of the project to go back in at the end of the project and button it all up, set the lot corners that got tore out, reset the street monuments, all that, do the final buttoning up of that plat at the end of the day. The same thing applies with boundaries. We're the first one to find the problem. We come up with a solution, get it documented, and once it's documented, we got to finish a survey and get the survey in the record that says, here's the solution to that problem. And then the next generation of surveyors can pick that up and perpetuate the solution instead of the problem.
We got a good one in the chat that could take us a couple minutes to discuss, but Justin says, let's say a surveyor shows boundary lines obtained from record on top on a topographic survey, because he caught himself there, on a topographic survey without looking for field monumentation. He notes that on the face of the plat, boundary lines are based on record documents. If adjoining owners rely on these boundary lines and make improvements, will the survey be liable for both adjoining owners if perchance a glaring encroachment has been discovered?
Well, what you're talking about here is making something that looks like a boundary survey that isn't a boundary survey, and yet is a professional work product that can be misinterpreted as a boundary survey by a client. So the question isn't what you intended that thing to do. The courts are going to focus on, well, what did the landowner think he was buying? And did he think he bought a boundary survey? And did they then rely upon that representation, that opinion, to make their improvements? And if they relied on your opinion to make the improvements, well, you're right in the middle of now an estoppel claim. You know, it's probably not a boundary dispute at this point, because it's more of a negligence issue. Were you negligent in your representation that you made? And then it's a matter of, well, how many disclaimers can you put on a piece of paper? Exactly. Which is usually way too many. I'd rather put out a product that says what it is than put out a product that says what it's not.
Yep.
And yeah, you can end up in a negligence issue, a negligence claim at least. And no matter whether you are right or wrong, can defend yourself or not, you're still going to have to defend yourself in the court of law to get out of the to get this claim to go away, at best scenario. So you're talking, what, 20 grand? Aren't you better off to just include a boundary survey in your topo and just do the survey work, determine where the boundaries are, and make the right representation, determine where the real boundary is too. No, I'm not talking about showing the deed lines according to the record. Yeah, sometimes the deed lines are correct. Sometimes they're not. Sometimes the fence is the line. Sometimes the prior surveys are the line.
Yep. And I've had that.
Which time do you want to be wrong?
And we've chatted about this many times on Mentoring Mondays, which is my stance is, only send out what leaves your office must be defendable, right? And so can you defend that work that you just did by just showing record and that kind of stuff? Sean had put in there, isn't it only considered a true boundary survey if it meets the criteria? Oops, I just jumped down. If it meets the criteria for one and is certified and stamped by the PLS as one. So
you can argue that it may or may not meet the criteria. The first question is, what's the criteria and how well is that spelled out?
Yeah.
What is the standard of care? Did you meet the standard of care? And that standard of care is going to be probably some publication by your state society, or some societies have adopted them into their licensing board, licensing requirements. Usually those aren't spelled out very well, but the type of product you gave, some of the states actually have certain products, and each product type has certain things that have to be shown, which can be a good thing or not. You forget the north arrow, you're negligent, because it says you have to have a north arrow. Because they can get down to the little pittances like that they can start picking apart, which they will. But if you've got a well-defined set of requirements that say a boundary survey shows this, 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 and this, and this, then you can point at it and say, well, yeah, but the document I prepared doesn't meet those requirements. Well, did the question's always going to come down to, well, what did the client need? Did the client need a boundary survey? And did you produce something other than that? And if then you failed to meet the needs of the client, well, that's a breach of your contractual expectations. You failed to meet the needs of the client, and yeah, doesn't matter. You see, it doesn't matter whether you meet how well they're spelled out. You can still have a problem. And the problem really is that the door is wide open because you're not doing a boundary survey and not fulfilling the requirements to meet the needs. Yeah, there's going to be an issue. There can be an issue.
Yeah, Justin added more to that in the chat. The client was cognizant that we were just doing a topo survey, but after you completed the topo survey, he then asked you to show the boundary lines. Well, it sounds like a change order and all the different things to go to do a boundary survey. And then it goes on to say, will the note defend me as a surveyor, just a CYA? And if you follow chat, everybody's
CYAs, like I say, you can put a ton of notes on your survey as to what it's not.
Yep.
But if it's going to come down to what did the client need and what did they expect?
Right. And
if you gave them a product that on its face says, well, this product will not meet your needs, then you're still liable because you have to produce a product that meets the needs of the client.
Yep.
So it'll always come down to what did they expect? What did they see? What did they think they got?
Exactly.
And to them, it was solid gold.
Yep. That's awesome. Yeah, no, that was a great way to end that conversation there, Justin. I know is that a good stopping point for you as well there, John?
Sure. Yeah. I think so. Oh, I did want to, I thought I had one more thing in here from Cooley, but I guess not.
Okay.
No, that's fine. I mean, these are just some of the types of documents: correction deeds, boundary adjustments. Boundary adjustment creates a new line, where a boundary agreement establishes the location of the existing line. Affidavits, survey narratives, depends on your jurisdiction and what each situation requires.
Right.
I've done all sorts of, I gave a bunch of examples in my material there of things that I've done in the past, and I do them differently now because some of those I've done a number of years ago. I'm always working and improving and trying different things, and because meeting the situations that are at hand each time. But I find that you'll make a lot more money stopping work and doing addendums to fix the problem and then finish your survey, and you come up with less liability and a better product and more satisfied clients.
Right.
You'll get Christmas cards. It's astounding.
There you go. I've talked about it a couple of times, but I've recently got a boundary line adjustment through one of our local jurisdictions after 16 years. It's my longest ever survey.
Yeah. I've got one here that one of these examples I threw out here. See if I can find it here. That this one. I got a thank you phone call from the recorder's office for this one. Properties that were shifted 80 feet out of position from tied to a section corner. That the section corner there today, the brass cap today, is obviously different than it was in the 1800s. And so I did a boundary line agreement that involved 7 parcels, 8 parcels. Yeah, eight different pieces of property. Did one boundary line agreement with all 8 parcels. New descriptions of each one, had all of these all the parties agreed to all the boundaries, which fit their deeds. Just had to put them in the right place and say, well, the section corner is really over here. Other than that, we didn't change the descriptions much at all to fit the fences. They were basically the same. Same widths, held the deed widths and everything. One document, though, that's about 15 pages long, with all the signatures and all the legal descriptions that we needed. And there was one boundary, parcel 7, did not want to sign an agreement with parcel 1 because this boundary here that they've got on the west side of parcel 1, he wanted to get an easement. Parcel 1, he wanted an easement to put in a water line to get back to his property. And parcel 1 said, no, I'm not going to give you an easement. I'll sell you one maybe, but no, I'm not going to give you an easement. And so he said, well, okay, fine. Well, I won't sign the agreement. So I last minute had to go meet with him at his kitchen table. And then I went over and met with parcel 1 and said, and basically formulated the whole thing with all the cross easement, cross conveyance language in it, and put in a, if you read the last paragraph of all the cross conveyances, it's like parcel 7 agrees with parcel 1 as to the back line, and then 2 and 3 and 4 as to the descriptions. I just kind of buried it in there that really there's not an agreement between 7 and the west boundary of 1. And I was like, okay, fine. You know, we'll just stick it in there anyway. And he was fine with that as long as he didn't have to agree with parcel 1.
That's awesome.
But all the other ones who did it. Yeah, and I got a thank you call from the recorder's office that said, they knew that this was a problem for years. They had surveys that were surveyors putting survey markers on the south side of this road out in people's front yards, saying that was their south boundary, and then cutting them off, 85 feet in the back. It was crazy. But yeah, it was a problem that everybody knew was there, and nobody ever told them they could fix it. Came up with a way to fix it, so we did.
That's awesome. Well, that was great conversation as well as always. The last 2 weeks have been phenomenal. Next week, so Ron Nelms will be back next week, and John went through mediation. That didn't work, so now Ron's going to court for us. So he's going to get next week's presentation is preparing for an expert witness, since John's mediation didn't work.
Yeah, that's when your mediation fails.
That's right.
When your
That's
mediation
right.
fails, you got to go in there to. And
That's
still, when it goes to litigation, stay in the game until it's over,
There
so
you
that
go.
you're there to document the solution at the end of the judgment.
There you go.
Helping the attorney write the judgment.
That's awesome. And then Wisdom Wednesday is back this week, and this is chapter 11, procedures for locating boundaries described by words. So we're gonna have to use your judge's legal description as a prime example. place this on the ground.
Yeah.
That's awesome. But that was a great conversation. I'm glad we didn't cut it off early, and we really got into some good stuff right at the very end, as always. So I appreciate everybody's time, and have a good week if we don't see you on Wednesday, and we'll be back next week. So awesome, John.
All
Thank
right.
you.
Thanks again.
Thanks, everybody.
Thanks, John.
You
Bye,
bet.
guys. Have a good night.